Law number 2. My name is Judge Terrence Holmes. I'm the presiding judge here this morning. That paperwork that you have in your hand, I will be going over that paperwork with you in a little bit. You have been asked to come to county court at law number 2 because you have a case in county court at law number 2. Now, your case is classified as a misdemeanor case. Felony case, criminal cases are divided into felonies or misdemeanors. Your felony cases are your most serious type cases. And your misdemeanor cases are referred to as your petty offense. It does not mean that they're not serious. It's just that they are not as serious as a felony case. If you had a felony case, it could be in one of 5 categories. It could be a state jail felony, third-degree felony, second-degree felony, first-degree felony, or capital murder. If you are convicted of a capital murder case, the range of punishment is life or death. If you're convicted of a first-degree felony case, your range of punishment will be 5 to 99 years to life, fine up to $10,000. If you are convicted of a second-degree felony, the range of punishment is 2 to 20 years, fine up to $10,000. If you're convicted of a third-degree felony, the range of punishment is 2 to 10 years in the state penitentiary and a fine up to $10,000. If you're convicted of a state jail felony, which is the lowest felony, the range of punishment, minimum 6 months to a maximum of 2 years in the state jail, fine up to $10,000. Now, for the misdemeanor cases, misdemeanors are divided into 3 categories. You have the Class C misdemeanor, the Class B misdemeanor, and the Class A misdemeanor. If you have a Class A misdemeanor, the range of punishment is 0 days to 365 days, which is a year in the county jail, and or a fine up to $4,000. If you're convicted of a Class B misdemeanor offense, the range of punishment is 0 days to 180 days, which is 6 months in the county jail, a fine up to $2,000. Or you could be given both such fine and confinement. If you are convicted of a Class C misdemeanor, the range of punishment is fine only. You cannot be given any jail time for Class C misdemeanors. Now, county court at law handles Class A, Class B misdemeanor, and we handle Class C misdemeanors when they are appealed either from the city court, which is the municipal court, or the JP court, which is the Justice of Peace Court. Now, as a defendant in a criminal case, you have rights. The document that you have in your hand talks about one of the rights that you have, which is the right to have an attorney. And I'll go over this document with you. It states that as a defendant in a criminal case, you have 3 options regarding your right to have an attorney. Number 1, you may hire an attorney. Number 2, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Number 3, you may represent yourself. If you want an attorney to represent you and you have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. At the bottom of this document, it states defendant's choice. Mark initials next to only one choice. If your choice is, I want to reset this case to hire my own attorney, then you will place your initials on the first line to the left. If you have already hired an attorney, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If you want to apply for a court-appointed counsel or court-appointed attorney, then you will place your initials on the third line to the left. If you've already been appointed a court-appointed attorney in this case, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. If you want to waive your right to an attorney and represent yourself, then you will place your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines, then you will sign your name on the line that is titled defendant, and you will date it today's date, July 19th, 2022. Now, for those of you who will be waiving your right to an attorney and representing yourself, then you will have to read and sign the second page. That second page is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And it reads, I have been advised of the nature of the charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 19th day of July of 2022 by the County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge, if I am not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that's your choice, then you will sign your name above the line that is titled defendant, and you will place today's date above the line that's titled date, and today's date is July 19, 2022. You have other rights, or you have more rights as well. Another right that you have is a right to have a trial by jury. And what a trial by jury is, in that area over there where those young people are sitting, we call that the jury box. 6 citizens from Jefferson County will be selected to sit on your case. They will listen to all of the evidence, and after listening to all of the evidence, they will deliberate, and then they will decide whether or not you are guilty or innocent. Now, you have a right to waive your right to have a trial by jury. Waiving your right to have a trial by jury means you have a right to give up your right to have a trial by jury and not have a trial by jury. And if you do not, well, if you waive your right to have a trial by jury, then your case will come before the judge. It will come before the judge in one of 3 ways. It can come before the judge by way of a trial, and the trial before a judge only is called a bench trial. Now, you also, it can come before the judge by way of a plea bargain. It can come before the judge by way of what we call a agreed plea bargain. And if it comes before the judge by an agreed plea bargain, that simply means that you and your attorney have reached an agreement with the district attorney's office to settle your case. And that's an agreement. That's a plea bargain agreement. That case will come before the judge, and the judge will decide whether or not to follow or not follow the plea. When I say follow the plea, go along with the plea or not go along with the plea. If the judge does not go along with your plea bargain agreement that you have reached with the district attorney's office, then you can withdraw or you can take back your plea. And when I say plea, that is if you enter a plea of guilty or no contest. Now, if the judge does follow the plea bargain agreement, and if you decide that you would like to appeal your case, that is, you would like to have a higher court than this court to review your case to see whether or not you have been wrongfully convicted, or whether or not this court has committed an error by convicting you, then if that's the case and you would like to appeal your case, you would have to get permission from the court or permission from the judge. Now, if the judge gives you permission, the case will go to the Ninth Court of Appeals, which is right above us on the 3rd floor. They will review your case. They will decide whether or not to grant or deny your appeal. If they grant your appeal, then they can simply find you not guilty, or they can send the case back down to this court, order this court to give you a whole new trial. If they deny your appeal, then you can appeal it to a higher court than the Ninth Court of Appeals. That higher court is called the Texas Court of Criminal Appeals. It is the highest criminal court in the state of Texas. They're located in Austin, Texas. You'd have to file what is called a pro se petition for discretionary review. Pro se means that you'll be representing yourself and you'll be petitioning the Texas Criminal Court of Appeals to review your case to see whether or not you've been wrongfully convicted, whether or not this court committed an error, whether or not your appeal should have been granted. If they grant your pro se petition, they can find you not guilty, or they can send the case back down to this court, order this court to give you a whole new trial. Or if they deny your appeal, then your conviction will stand at that time. So going back to your right to have a trial by jury, and if you waive your right to have a trial by jury, you can have a bench trial before the court, or if you your case can come before the court by way of a plea. It can be an agreed plea bargain, or it could be an unagreed plea bargain. Now, you also have a right to have witnesses to come to court. You have a right to call witnesses in your trial. Where that gentleman is sitting over there in that chair, we call that the witness stand. And what witnesses do, they can testify in your case. They can testify for you, or they can testify against you. If you're representing yourself, you can ask some questions, or if your attorney, if you have an attorney representing, your attorney could ask some questions. And we call that either direct examination or cross-examination. Now, you also have a right to waive or give up your right to have witnesses to come to court to testify in your case. Now, if you waive or give up your right to have witnesses to come testify in your case, that doesn't mean the state will not be calling witnesses. You will not be calling witnesses, but the state will be calling witnesses to testify in the case. Also, you have a right against self-incrimination, a Fifth Amendment right against self-incrimination. And what that means is you have a right not to testify in your own case. And the district attorney of the state cannot force you to testify against yourself in your case. Now, you can waive or give up that right against your Fifth Amendment right against self-incrimination. And what that means is if you waive or give up your Fifth Amendment right against self-incrimination, that simply means that you will be testifying in your case. You also have a right to have what is called discovery. Discovery means you have a right to see the evidence that the state has against you in your case. Now, and you can see the documents, you can see witness statements, you can see, you can have access to the videos, recordings, instruments, whatever they have in the case as evidence. You have a right to have access to that evidence. Now, you also have a right to waive or give up your right to have discovery. And that simply means that you do not want to have access to the evidence that the state has in your case, or the state will be using against you in your case. Now, everyone that's here is here today because you are out on bond. You're either out on a what we call a personal recognizance bond, which is it's normally referred to as a PR bond, or you here on what is called a cash bond, meaning that you put up the cash, the full amount of the bond, or you here on a surety bond, which means that you have a bondsman on your case. Now, every day that you spent in jail on your case, you can get credit toward your punishment in your case. So for example, if let's say you spent 5 days in jail, and let's say you and your attorney have negotiated with the district attorney's office for a plea agreement, and the state or the district attorney is offering you 5 days in jail. What that basically means is that you would not have to serve any more time in jail because you've already served 5 days in jail. Therefore, you'll be given credit for time served. Now, if they offered 7 days in jail and you served 5, that means you would have to do 2 days in jail. If the state is offering you a fine, now every day that you spent in jail, you can get credit at $100 per day that will go toward your fine and court costs. So for example, if you spent 5 days in jail, that's $500. And if the state is offering you a fine and court costs of $500, that means you would not have to pay anything because the time that you spent in jail has already paid it off, and the fine will be taxed, the fine and court costs will be taxed and retired. Now, if they're offering you fine and court costs of $700, that simply means that you would have to pay $200 because you already have $500 of the 5 days in jail. Now, if you cannot pay the fine and court costs on the day that you enter the plea, let's say you cannot pay the $200, then the court can allow you to pay your fine and court costs off in installments, which means you could be put on a payment plan. You could pay it off so much, you'll be able to pay it off each month. Now, if you cannot pay it off at all, let's say you do not have the income, even if we put you on a payment plan, you still will not be able to pay it off. Then we can convert your fine and court costs to community service, and you can work it off. Now, with community service, every hour of community service that you work, $12.50 will go toward your fine and court costs. So if, for example, if you work an 8-hour day, 8 hours of community service, that's $100 that will go toward your fine and court costs, okay? So now, everyone that's here today, as I said, you out on bond. Now, the state has a program that is called pretrial diversion. Pretrial diversion is a program, when I say the state, I'm talking about the district attorney's office. With the pretrial diversion program, every one who is qualified, you can apply for pretrial diversion. And in order to qualify for pretrial diversion, one, you have to get an attorney to assist you to get in the program. 2, you cannot have a criminal history. And 3, your offense cannot be resisting arrest or unlawfully carrying a weapon. Now, with the pretrial diversion program, if you get into the program, your case will be dismissed. And once you complete the program, you can get it expunged from your record. Expunged means deleted, erased, or wiped off from your criminal history. And as I said, in order to get the program, that program is run through the Jefferson County District Attorney's Office, and we have the paperwork here that you can fill out to see if you can get into the pretrial diversion program. The other thing is, if you are a veteran of any one of the branches of the United States military, the Jefferson County District Attorney's Office also has a program that is called Veterans Court. It is also part of the pretrial diversion program. You get into the program, the case, and you complete the program, your case will be dismissed, and you can get it expunged from your record. And we have someone here who is from the Veterans Administration. He's going to come up a little later and he's going to tell you more about the programs that they have with the Veterans Court and the programs that the Veterans Administration has for veterans. Now, Jefferson County, County Court at Law number 2, this court has a program that is called the Community Safety Initiative. It's the CSI program. And that program, I started that program in March of 2017, within 100 days of taking office. And that program is designed to address the issue of what we call recidivism. Recidivism is when people commit crimes over and over. And so how do we address that? How do we prevent that from happening? Well, we have the community safety, or the CSI program. And with this program, we have partnerships with Jefferson. Well, we have partnerships with Spindletop, and Spindletop is our local, the Spindletop Center is our local mental health agency. Matter of fact, we have individuals who are in the jury box from Spindletop, and actually Spindletop will come up a little later and tell you a little more about that program. Now, basically what Spindletop will do, they will do private interviews, they can do an assessment, and they can develop a treatment plan, either outpatient or inpatient treatment to address mental health needs. Now, when I say to address mental health needs, you do not have to be incompetent or insane for the program. The program will be able to address individuals who have depression, anxiety. They could be paranoid, schizophrenic, bipolar, ADHD, manic depressive. It's just a whole host of mental illnesses that they can address. Also, we have a partnership. They also have a program called ATAR. ATAR stands for Addiction Treatment and Recovery. And it's a drug treatment and an alcohol counseling program. Also, individuals who have issues with drugs or alcohol can be referred to the ATAR program or to the Alcohol and Drug Abuse Council. Their program is called OZAR, which stands for Outreach Screening and Assessment Referral. With those programs, you will be screened, they will do an assessment, and then treatment plans will be developed so that they can be addressed. Either drugs or alcohol, could be a combination. Now, sometimes we have what is called co-occurring disorders. Individuals have problems with drugs and alcohol as well as mental health issues, and those issues can also be addressed as well. Now, if you are unemployed, do not have a job, or you'd like to get a better job, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training program and a job placement program in the hotel industry, the shipping industry, or the chemical industry. Once you are trained in one of the areas that you select, then they will assist you at getting a job in the area that you're trained in. Now, if you have not graduated from high school and you would like to get a GED, the CICE program also has a GED program for individuals to help, so they can help to get their graduate equivalency diploma. Now, all of these programs that I have just mentioned to you are free. It does not cost you anything. Only thing you have to do is have a desire to be in the program. And I tell people all the time, when you come to County Court at Law number 2, we do not have court as usual, we have unusual court. And it's not because we're different. It's because we're trying to make a difference in the lives of the individuals that comes before this court, and we're trying to make a difference in Jefferson County, the county in which we live. We do not just arrest the problem, we address the problem. And so we do not just give time, we take our time. So the whole point or goal of this program is to produce productive people. And if you're interested in this program, just let court personnel know, and they'll be able to help you with getting the information that you need to get into the program. Now, at this time, as I stated earlier, we have individuals. We have Wade from our Veterans Administration. He's going to come up to you and talk to you about the Veterans Court, and then after Wade come up, then Deputy Hinton is going to come up to you and talk to you about the program that they have to offer with Spindletop. Wade?
Good morning, my name is Wade Adair. I'm the Veterans Coordinator with the Texas Veterans Commission and the Jefferson County Court Officer offers a Veterans Treatment Court. And the veteran here today would like to talk to you about that, and talk to you about how you qualify. If you are a veteran, you need some assistance navigating VA affairs, medical or benefits, or are you looking for resources or benefits in the community, I'll be glad to talk to you about that. Or we have a family member that's a veteran that I can assist, I'll be here to talk to you as well. So do I have any veterans here this morning? Okay, all right, thank you.
Okay, thank you, Wade.
Thank you, Arthur.
Deputy Hinton?
Thank you, Ron. Good morning. My name is Steve Hinton. I'm a mental health deputy licensed by the state of Texas. This is my partner here, Sarah. Sarah is a qualified mental health professional with Spindletop. We work closely with Wade, Veteran Affairs as well. The reason we're here is because the judge has graciously allowed us in his courtroom because he cares about every single person who comes before him. What the judge has found, more so than not, that people who appear before his court commonly have either mental health or substance use disorders, or just lack of connection to community resources that can be beneficial to you. The judge believes if we can help you with that, we can get you out of the cycle of arrest. Now, we found people who've been here for the first time. We've also found people who've been here 10 times. The point is, we want to get you out of that cycle if we can get you connected to those resources. But this is going to be a choice that you're going to have to make. So I'm going to ask you to do something that may be a little uncomfortable this morning. I'm going to ask you to share that need with Sarah or I after the court goes in recess so that we can visit with you directly and maybe help you and provide resources or whatever that be beneficial to you in your particular situation. Now, main thing I want to give you this as well. This is a flyer. It tells you a little bit about what we do on the back, and on the front it has a 1-800 number. It's a crisis hotline number. Should you ever find yourself in an unsafe place, you can call that number and get help immediately. So we're going to be here during the duration. When the court goes into recess, we'll be visiting with each of you. I think there's a page, a demographic sheet that we've asked you to fill out. We'll also, if you don't want to speak here in court, I understand that. If you want to fill that out and complete that, we would be glad to follow up with you at a later time where it'd be more convenient for you as well. That way we can get you connected to whatever would best fit your particular situation. Now, maybe this doesn't apply to you. Maybe it applies to a family member. If so, we would still love to work through you to get to that family member and help them as well, should this be something that y'all would see value in for them as well. Thank you very much. Thank you, Your Honor.
Okay, thank you, Deputy Hinton. Now, gentlemen, the paperwork that you have in your hand, if you need some assistance, we have court personnel here who will be able to assist you with filling out the paperwork. At this time, the court is going to go into recess, and the reason why we're going into recess is to give us an opportunity to make sure the paperwork is completed properly. And once the paperwork is completed properly, we will call you up to the bench one at a time. So at this time, the court will be in recess